Yes, I'm sorry to have kept you. We were discussing and got carried away by the interesting points in this case. Anyway, here we are now.
My Lord, I appear in this matter with Mr. Jack Feeney on behalf of the Appellant Government Departments, and my learned friend, Mr. Oliver Siegel, KC, leading Darshan Patel, represent the various individual claimants and also the Public and Commercial Services Union. My Lord, as you will appreciate, these are consolidated appeals from 3 decisions of the High Court, 2 decisions of Mr. Justice Choudhury and 1 from Mr. Justice Friedman. And they're concerned with the legal consequences of the removal of the check-off arrangement by different government departments in the middle of the 2010s. And check-off, as you probably know, is the arrangement whereby trade union membership dues or subscriptions are deducted at source from the payroll and then paid over directly to the trade union. Just in terms of housekeeping, I just want to make sure that your lordships have the relevant bundles. There should be a core bundle with respect to each of the appeals, as well as a supplemental bundle relating to those appeals, and 1 bundle of authorities. And
that's correct. I am rather displeased by the bundle of authorities. I don't know who put it together, but for example, the law reports used are the industrial relations law reports, which are not the ones that should be used where they're reported in the ICR, and nothing against the IRLR. I've used them all my life, but they are actually in some respects less useful. They have a different form of head note, and when we write the judgments, we have to refer to them in the ICR, and it's a nuisance not to have the right references. There are no tabs. Who put them together?
My Lord, my understanding is that it's my
oh, sorry, Mr. Feeney, I didn't mean to put you in the dock. But what tends to happen is, and it's something we just need to keep an eye on, is counsel hand it over to their clerks or some librarian in chambers without checking whether they actually know what the relevant rules are. And that whatever happened here, can it not happen again? Yes. But we have a bundle of authorities, and we will, of course, use it despite its deficiencies.
My Lord, would you like us to...
Oh, sorry, just one more thing. There are also printouts from the from Chitty and so on, which are perfectly legible, but it's much better to have them in PDF form. They've been printed straight off the net, where I think, maybe I only speak for myself, I rather like to see them as they appear in the book. Again, that means you can get page references.
My Lord, would you like us to produce a more polished version of the bundle?
I should have discussed this with my lords first, but I think life is too short. We'll cope.
Also, not a question of polish. There is a practice direction.
Yes.
It's not choice. There is a practice direction, and if you're going to depart from it, there should have been a reason for it.
Yeah. Well, my Lord, there is no good reason for departing, and we apologise to the court.
Okay. Well, we got that off our chest, but don't do it again. We have the bundle of authorities, yes.
And within the core bundles for each of the cases, there are the skeleton arguments for both sides.
Yes.
So, my Lord, just to set the scene, in the case of Cox, which is the Home Office case, and the check-off was removed on the 1st of December 2014. In Crane, which is the DEFRA case, check-off was removed as at February 2015. And in Smith, which is the HMRC case, check-off was removed as from the 1st of May 2015. The claims in this case were brought towards the very end of the 6-year limitation period. In Cox, 9th of October 2020, Crane, 27th of January 2021, Smith, 24th
Well,
March
is that? I mean, it may
2021.
not matter because it's within the limitation. I'm not actually quite sure what the union will have a fresh cause of action, won't they? Each payday that goes by without them receiving, without a deduction being made and paid to them.
Not in respect of these claimants.
Oh, I see.
Because these claimants did, in fact...
But because damages have been hived off, I'm not quite sure how the damages are being put, but...
well, the way in which we understand damages are being put is that the trade union should be entitled not only to the cost of having to make the alternative arrangements in terms of manpower and so forth, but also the loss of subscriptions, not only for those who did sign up to direct debit, but also for those who didn't sign up to direct debit.
Yeah.
So in a sense that they've lost their membership dues forever. That's the basis in which they're putting.
How can there be a claim for damages? Do you mean for the period before they sign up to direct debit?
Well, that's part of the damages claim. The remainder of the damages. So in Cox, I think the damages being sought are over £3 million. It's in respect of everyone who didn't sign up.
But it can't be, well, this is perhaps something that we will have to discuss with Mr. Siegel when he's on his feet. But on the face of it, it doesn't seem right that you can claim damages or arrears, anything, for a breach of Mr. Cox's contract, as a result of damages for a breach of Mr. Cox's contract, reflecting anything else other than what you've lost from Mr. Cox.
Yes, but the way in which the matter is pleaded is that for the PCS claim is that everyone, they're relying not just on the individual claimants, but they're seeking a declaration in respect of every other employee who was a member as at the particular date when Chekhov was removed.
That's what you said, 132. The individual claims under like breach of that term of all PCS members employed with the defendant as at 1st of December.
Yes.
That's what they've
And
put.
then something similar in respect of each of the other claims.
Yeah.
So, my Lord, we appreciate that damages has been hived off, but obviously, and it may well be, many of the arguments we're running are trying to find different ways of reducing the damages claim if we are not successful on our fundamental point that there's no claim at all.
Yes, I mean, again, I've just flagged this up because it might feed back into the question of the party's intention for the purpose of section 1.2. If PCSU get a declaration of the type they are seeking,
Yes.
which is not tied to any particular person's contract, in principle, the exercise would have to be done, not just of identifying who was employed on a particular date, but also when they'd entered into their contracts.
Yes.
My lord, I wonder if I could assist, just because I know the friend wasn't in the earlier case of Kavanagh, which went rather further in, towards a remedy hearing, and I can explain.
All right, Mr. Siegel, as long as you don't take advantage of this.
Not at all. Just to explain what the remedy claim is and how it was dealt with in the previous case, not by the court because eventually it was compromised, but my lord was absolutely right. There's no claim, of course, for people who transferred onto direct debit, nor is there any claim, as my lord just Underhill implied, for anybody who didn't enter into a contract after the relevant date. The claim is in respect of those who had entered into a contract after the relevant date and who did not transfer, subject, of course, to arguments which were made and accepted.
So when you say who did not transfer, what do you mean?
Sorry, did not transfer their subscription from Chekhov to some other means of payment, direct debit, my mistake for lack of clarity. And argument was made in Kavanagh and was accepted that, of course, one has to adopt some form of analysis to establish the percentage or number of people who would in any event over time or immediately not have continued to pay
Sorry,
their-
can you speak up slightly?
Sorry, speed up, did you say?
Speak up.
Oh, speak up, sorry. The argument was made that PCS might well lose membership over time in any event.
Well, there are
That had
delicious
been-
causation problems.
Exactly. All of those were made and accepted, and an analysis was done, and schedules and counter schedules were exchanged, and the matter was compromised in Cabinet. And remedy has been, as my lords know, stayed in 3 cases with which
Yeah.
this court
Okay.
is now concerned. But that's the way the claim.
Okay, but the real point is that you appreciate quite a sophisticated sort of analysis is required and was gone into in Cabinet, though not by the court, because it's settled.
To some extent, it was gone into by the court in order to prepare the parties
Yeah.
for the exercise that they then were able to complete without further court determination.
And forgive me for not having checked, but page 132 of the Cox bundle has the prayer. And the individual claimants claim a declaration of entitlement.
I would, yes.
PCS claim a declaration that they're in the mix as well. And PCS, but not the individual claimants, claim damages.
That is correct.
And that's common across the board, is it?
My lord, I believe, yes.
And so the PCS claim would have to be founded upon the existence of a directly enforceable right by PCS.
Absolutely.
Okay, thank you. That's been a useful digression, I think. But let's get back. Thank you, Mr. Siegel, for your help. You
My lord.
now get back on track.
If I can continue, but obviously you will ask questions as I go along. My lords, in the High Court, as you will appreciate, the government departments, which is my collective term for the various appellants, argued that there was no individual contractual entitlement to the check-off facility. We were unsuccessful with that argument, and permission to appeal from this finding was refused by Lord Justice Lewison. The appeal today proceeds, therefore, on the basis that the individual civil servant claimants did have a contractual entitlement to check off when it was removed. And that's the basis.
If and to the extent that they requested it.
If and to the extent that they requested it, yes.
That raises the question of what the term is. I've wondered whether the term is a facility maintained whereby employees can request money to be deducted and that will be transferred to the union. So the right is the right to a facility, or whether it's the right to have deductions done individually. In one sense it doesn't matter, but it may matter, because if the benefit is the former, the benefit of the facility, that's one thing. But if it's the individual payments each time they notify that they want to pay, may be slightly different. The one is a facility, the other is a sum of money.
My understanding is that the claim and the contractual term is on the basis of the facility.
Yeah.
Because what one will go on to say is after check-off was removed, no individual claimant, and in fact no one at all, came to the employers and said, I would like to continue, I would like you to deduct from source for the next month, and the next month, and the next month, and the next
Have we
month.
got evidence of that?
Well, my lord, none of the claimants here say that that's what they sought. They all say, well, we moved over to the subscription to
The
the direct
contractual
debit.
term it was to have the defendant maintain a facility whereby they could authorise deductions and they would be handed over.
Yes. And obviously we say one of the inferences that one should draw from that is that they varied the contract and or waived the breach, but I'll come on and develop that. Permission to proceed with an appeal was granted by Lord Justice Lewison in the Cox case on 3 grounds, which you will find in our skeleton argument in Cox, that the initial skeleton argument for permission to appeal on page 13 in the Cox bundle. And it's the second, it's under paragraph 2 and it's little 2, 3 and 4.
Why are we looking at it there? Isn't it easier to look at
It's
this
just
in your...
it's the easiest place, my lord, for us to find it.
Okay. But don't we also see them in the skeleton argument for this hearing?
We do see it in skeleton argument
Yeah.
hearing, but it's just that's the first page that I've come to in my bundle.
I see. Okay.
So ground one was refused permission. Ground two, that the judge erred in finding that the individual claimants had not varied their contracts to exclude check-off and or waived any prior breach. The conclusion that the parties did not intend that the term would not be enforceable by the fifth claimant, as per section 1.2, was wrong in law. In particular, the judge misconstrued and misapplied the reasoning in Hooper. And fourthly, there's a very specific point relating to whether the second and fourth claimants entered into new contracts.
Yes.
There is a further point which has been raised on appeal, which the respondent claimants do not object to, which is whether or not section 1.2 should be read in terms of what does parties mean? Is it singular or plural? And then there's a further ground of appeal with respect to the application of sections 2 and or 3 of the 1999 Act, which is what is the impact of a variation and or waiver on the 1999 Act, third party right. With respect to the individual facts, there are differences in the cases, but there is a considerable commonality. In terms of the legal principles that apply, we say they are the same or should be the same with respect to each of the appeals. Just to give you a roadmap of where my submissions are going, I intend to set out in very brief terms some of the factual background. Then I will make submissions on the 1999 Act with respect to intention of the parties, assuming that it's plural rather than singular. And then I will look at intention of the parties singular. Then I'll deal with waiver and or breach, and waiver of breach and or variation of the contracts, and look more specifically at the facts of the cases. I'll then look at the impact of sections 2 and 3 of the 1999 Act, and then deal with the more minor points about entering into new contracts. So, my lords, in terms of background, in the mid-2010s...
We have, of course, read the papers
my lord,
very carefully, so you take this as thoughtfully as you wish, but there may be some points you want to highlight, I accept.
My lord, I'm going to be very brief here.
Okay.
And I do appreciate you would have read the judgments. In the mid-2010s, various government departments informed trade unions that they were intending to terminate the check-off arrangements. The practice of check-off had originated in a collective agreement between the government side and the trade union side. And we see discussion of that in the Crane decision, Mr. Justice Choudhury's decision, which you'll find in the Crane bundle. Judgment begins at page 40, my lords, and I wish to just take you to paragraph 6 on page 42. So Crane bundle.
Which page do you say, I'm so sorry?
So this is page 42, my lord.
Yeah.
Under there, there's a heading background, then there's a heading the origins of check-off. And what Mr. Justice Choudhury says is the origins of the check-off arrangements lie in collective agreements reached between the government and the relevant trade unions in the 1960s. There was no direct evidence of such agreements before me. Unsurprisingly, many of the documents from the period can no longer be located. I would refer to a research paper which confirms that in July 1965, the Treasury offered to provide check-off to the staff associations recognised by the government at the time, including PCS's predecessor, thus suggesting that this was the source of check-off for civil servants working for central government. And my lord, in the Cox case, if we pick that up, my lord, that's at page 94 in the Cox bundle. I'm not going to come back to Crane until much later. But in the Cox bundle, page 94 is where the judgment starts. Mr. Justice Choudhury set out the historic background to the check-off arrangements, tracing them through the various policy and guidance documents. Why that was important, my lord, is because this is not a case where an individual employee has a contract of employment document which contains all of the terms. One has to look at a variety of documents to ascertain what the terms are.
Yes, nobody is taking the point, which I appreciate is very out of date and shows my age, that civil servants don't have a contract of employment.
My lord, we're not taking that point in this case, but obviously that is part of the background to why some of the documents would have been written in the way that they were written.
Perhaps you may not want to do this on your feet, but at some point we used to have a sentence or two about, as it were, where the government stands on that issue. I'm aware that the whole trend has been, say, in the real world, of course they have contracts of employment, and of course they have statutory statements of terms, at least I think they do. And they have all these sorts of miscellaneous documents, so in practice you can work out what the terms are. But has the government ever formally given up what, when I was studying, was regarded as the position that civil servants don't have contracts of employment?
I don't believe the government has formally given that up, but for the purposes of this case and the two previous cases that were heard, as we'll come on to, Hickey and Kavanagh, the point was not taken. So it's not.
So we can't look back at some moment in history where it is finally acknowledged that civil servants have contracts of employment. It's just a point that has not been taken for some time.
My lord,
in most contexts, it doesn't matter because they obviously have statutory rights anyway.
Exactly. My lord, I will just confirm this with
Why not? It's not a bit. The case isn't a turn on it, but if there's a judgment which alludes to this point, it's important that we get the government's position accurately. Yep. So feel free to do it after lunch. I'll take instructions.
I think those behind you have a clear view.
They have a clear view. And I just, if you,
yeah, I don't want to say anything that mucks anything up, but
if you just let me turn for 1 minute to ask.
Well, if you like, but why not do it properly when I just want to flag this up so that we don't say anything that is wrong.
I'm not going to say anything more on the matter until I've taken instructions.
I think that's better.
My lord, in Cox, paragraphs 3 to 5, Mr. Justice Choudhury explains where the check-off arrangements appeared in different guidance documents. They were initially set out in the Civil Service Pay and Conditions of Service Code. That was the source of terms and conditions. It was a centralised source of terms and conditions before there was delegation to individual government departments of the ability to set the terms and conditions, those working within their area. Following delegation, a new code, the Civil Service Management Code, was introduced. That also contained reference to check-off, and individual departments' terms and conditions had to comply with that code. I haven't sort of gone back over this because we're not appealing this point, but the explanation is set out there, or the analysis is set out there. I can't second guess it for these purposes. You'll also see reference in the Kavanagh judgment of Mrs. Justice Lane, as she then was.
This is Justice Elizabeth Lane.
Elizabeth Lane. My lord, at paragraph 49 of Cox, Mr. Justice Choudhury he looks to see whether or not the term the wording set out in the various guidance documents and codes are apt to form part of the individual contract. And he concludes that they are, and he analyses that on the basis of, well, if the language used is not that of contractual obligation, then it may not be correct to infer the parties intended the provisions that have effect. And he starts by looking at what he called the root documents. The first of the codes that I referred to, and then the second of those codes. The point that I seek to emphasise is that those root documents themselves have a source, themselves are derived from, for these purposes, from the collective agreement. And at paragraphs 50 and 51, Mr. Justice Choudhury goes on to analyse this, and again refers to the language of the common root and so forth. What's important for these purposes is that when one is seeking to construe the individual contract of employment for the 1999 Act purposes, we're not simply looking at one document. One has to look back through the history and understand from whence it came.
And just remind me, perhaps you've told me, how do we know that the original document, the CSPSC, was the result of collective agreement rather than diktat by the then government?
Well, no, the point is that the term relating to Chekhov, which is contained within the CPSC,
but how do we know
came
that
from a collective agreement.
Yeah, and how do we know that? That's what I want to know.
Well, my lord, that is what Mr. Justice Choudhury sets out at paragraph 6 in Crane. That was the passage that I took you to just before.
Crane.
And Mr. Justice Friedman says much the same.
Mr. Justice Friedman says the same,
of time.
and Mrs. Justice Lane, as she then was, Elizabeth Lane says the same thing in the Cabinet judgment.
Okay, so paragraph 6 and the missing link that I hadn't assumed. So there was a negotiation, and when they did the Civil Service Code, they incorporated a provision to reflect that collective agreement. Okay. And
my argument, as I'll come on to develop, is that's relevant when one is looking at the intentions of the parties under the 1999 Act.
But it's relevant at an earlier stage, isn't it? Because it would have been open to the employers not to make it a contractual term. Once it becomes a contractual term, it's part of a contract.
My lord,
you've lost the first argument.
We've lost the first argument.
So, but it remains a fact that they could have structured things in such a way that it was not a term of the contract of employment.
Well, they certainly thought they had done.
No, that's because an answer. That's not even the beginnings of a response.
Well, my lord,
it would be possible.
Yes.
Look at the ranks of people sitting behind you. It would be entirely possible to have structured things so that the right to Chekhov was not a contractual right.
My lord, it
and
would.
Unfortunately, you've lost that argument.
We've lost that argument. And my lord, you are correct. Of course, it would have been possible to construct things in a particular way which negative that expressly on the face of a statement of terms of particulars and so forth. But that wasn't done. And all I can add is it was not understood to be a contractual term with respect.
Well, it all goes back to, although I suspect the government has in many ways enjoyed the advantages of the civil servants not, at any rate historically, having contracts of employment, but it does have consequences. It means that these sorts of questions were probably never really focused on way back in the last millennium, when these things were first entered into, because they were all just matters of civil service guidance. Nobody had to think about whether they were terms of contracts, as there were no contracts, they thought.
Well, my lord, I think if one goes back and looks at the arguments that we ran in Cox on this point, one can see there is a distinction between the earlier case of Hickey, where in the staff handbook, which is the primary source for the civil servants working within the Department of Environment, Transport and the Regions, as it then was, check-off was within the bit of the staff handbook which was highlighted as a contractual term.
Yes.
So it was difficult, although they sought to argue, it was difficult to argue it wasn't contractual. In all of these cases, it wasn't highlighted in the part of the guidance which said it was a contractual term. So that would have been the first way in which the government departments would have sought to meet the point raised by my Lord Justice Stuart-Smith. But that's water under the bridge for the purposes of today. And you know, I can say, unfortunately for my clients, but that's the background. So the point that I'm seeking to draw from all of that is that the source, the root of the contractual term was a collective agreement with respect to check-off, which goes back to the 1960s. That's all I'm seeking to say at this stage. Moving it into the last decade, so in 2013, check-off was with, I'm sorry, it wasn't DETI, it was Department of Communities and Local Government. I apologise. A claim, check-off was withdrawn from the DCLG, and that was a term which was highlighted in the part of their handbook which says these are contractual terms.
So
That was Hickey.
better or worse, there may be other departments that don't feature this litigation, but the ones we know about, this is the department that took this step first.
This is the
In a
department.
particularly weak case.
They took the step first.
Yeah.
And in 2013, a claim for a declaration was brought by two individuals employed by that department, that they had a contractual right to require the department to continue to deduct their trade union subscriptions from their salaries and pay them directly to the trade union. And my lords, you can see that in the Hickey judgment itself, judgment of Mr. Justice Popplewell, as he then was.
By the way, we don't say as he then was in my court.
I will no longer waste time.
It's a foible of mine that I think we spend far too much time saying it.
I am encouraged by that. I appreciate that you don't have tabs, but we do have page numbers.
Yes.
And I'm going to take you to the page numbers. A115. And I appreciate this is from the IRLRs. And
Don't worry, no, I've said my say on that.
It is helpful for this particular paragraph. First paragraph, you can see where this all came from. There's a reference to the highlighting that I've said, but it's the second paragraph on the head note, which is what the claimants were seeking. And you'll note that this is not a case brought by the PCS. This was individual employees, civil servants, seeking to enforce a term in their contract of employment. One can see from the judgment in that case the speed with which that claim was brought. Paragraph 3, March 2013, the department informally notified the recognised trade unions that it was intending to terminate. The unions protested, they sought consultation. On the 15th of July, the department notified the trade unions and individual staff of the intended termination with effect from the 1st of September. And then at paragraph 4, the claimants issued proceedings on the 1st of August 2013. There was an application for interim relief. The matter came on before the court on the 8th of August, and they pressed for a speedy trial in the alternative interim declaratory relief. There was an order for a speedy trial.
Took place in the vacation.
And the trial took place on, certainly the judgment is on the 3rd of September 2013. So it really,
I think it's extemporary.
it may well be. So one can see that this was a very quick assertion of contractual rights. At paragraph 25, you see in the conclusion of his lordship, I accept the argument advanced on behalf of the claimants, and I conclude that the claimants are entitled to continue to pay their PCS subscriptions by deduction from pay by way of check-off by reason of paragraph 12.5.9, which is the reference to the start hand. This, my lord, is an example of individual civil servants who wanted that right to be maintained. They acted very quickly and they had very swift relief from the courts. I'm going to seek to draw a distinction with the present case where they waited almost 6 years. And they're not seeking damages, the individual claimants. They're seeking a declaratory relief for something which took place almost 6 years previously. The next case to come before the courts with respect to check-off was the Kavanagh case. That you pick up at A163. Case was brought against the Secretary of State for Work and Pensions. It's not a case in which there was a highlighted term, as there had been in the Hickey case. And in terms of the proceedings, if we pick up, my lord, paragraph 29, one can see the background to this. January 2014, the PCS was told that check-off had been reviewed. Discussions with the trade unions in the summer of 2014. Formal consultation, October and November. Decision to end the check-off on the 11th of December 2014. The department wrote to PCS to say that it would be withdrawing check-off from 31st of March 2015, later postponed to 30th of April. First month in which there was no check-off was May 2015. The claim in that case was issued, we don't have the actual claim form, but I can tell you the dates, I don't think there's any disagreement, was on the 20th of March 2015.
The claim form was 20th, the issue of proceedings.
Issue of proceedings in that case, 20th of March 2015.
Oh, before it was withdrawn then?
Before it was withdrawn.
We'd had the ICLRs, we'd have seen it in the section, yes?
Yes.
Okay, 29 timetables, so...
And there is in the bundle, my lords, there's a press release from the PCS on the 2nd of April saying they formally lodged papers with the High Court. And the claim was brought for a declaration by the individual civil servants and a claim for damages by the PCSU under the 1999 Act. The judge granted the declaration but did not deal with damages, and my learned friend has explained that followed after the event. But again, one can see the celerity with which they brought an action, both the individual civil servants and the trade union. Judgment was given on the 13th of May 2016, so a year after the claim had been issued.
When was the hearing?
Not sure the precise dates.
If we had the ICR, we would know.
Oh, my lord, you...
Sorry, I couldn't resist. No, keep going.
I can hear the record turning, and I can only
No,
on each occasion.
Lord Justice Lewis and I will restrain ourselves.
Why, there's a practice direction, he says, unable to restrain himself.
Well, we can now... The proof of that is certainly seen. Again, though, there's a swift action, and importantly for these purposes is that judgment in respect of the individual employees was in May 2016. Because, as I'll come on to talk about, there is reference to the individual claims. Well, said, well, we were relying on Kavanagh as a test case. Well, that doesn't explain then, after there was a judgment in Kavanagh in respect to the individual civil servants, why they waited for another 3.5 years.
Well, it wasn't set up as a test case.
Well,
My lords know much better about how than I do about how in this particular jurisdiction it would be set up.
It was certainly not set up as a test case.
It was not set up as a
No.
test case.
What the evidence before the courts below found was that the and I can't go behind that because that's the finding of fact based on the evidence of the PCS and some of the individual claimants, is they themselves regarded it as a test case, and the individual claimants themselves said, well, we knew that that was happening.
But it's a sort of combination of the two, isn't it? One, we're leaving it to the union, and two, we thought it was a test case.
Yes, but no one told anyone else it was a test case. There was no communication at all, as I'll come on to show you, from the period around the removal of Chekhov in these three cases, and when they sent a letter before claim and or issued proceedings almost 6 years later. Nothing, complete silence in the interim.
Can I just ask you, you opened this by saying various governments informed PCS they were intending to withdraw Chekhov. The memo from the Cabinet Office, as I understood it, went to all departments.
Yes.
Did some departments decide to ignore it?
Some departments didn't comply with it, as in they decided not to remove Chekhov for various reasons. What I can say is there's another 7 cases standing behind this case.
That's my next question.
Yes.
Another 7 departments.
There's 7 other departments who either claims have been issued or there's a standstill agreement. I can't quite remember.
But I mean, depending on the outcome of this case, if there are indeed 7 other cases, they cry out for proper management.
Well, my lord, I certainly understand that point.
I mean, this succession of cases saying, well, this is a bit different from the last one is pretty unedifying.
My lord, that point is well made. But not every government department did go ahead with it, but a number of them did.
What was the nature of this cabinet document then? Was it telling, could they tell government departments to do it? Was Secretary of State instructed to do it? Or was it just the government now thinks we shouldn't be providing this benefit?
My recollection was that it used the language of, it said it in code. It talked about departments are invited to review whether this is really necessary or something like that.
In Cabinet at paragraph 26, if my lord is interested in the history of this, there is.
It's also got that, it's referred to in one of the 3 judgments we've got, who refers to organisations whose interests don't necessarily coincide with ours or something like that.
Yes. And my lords, you'll appreciate the reason why different government departments can make their own decisions here is because terms and conditions are delegated to individual government.
In the sense, the minister can't quite have his cake and eat it if he's going to delegate terms and conditions.
Well, no, it's the Prime Minister has delegated. So, whereas initially, and sort of when the collective agreement was first entered into, it was between the Treasury on behalf of all government departments and the and the trade unions. In more recent times, there's been delegation, which is dealt with.
No, I understand that. I'm simply making the point, I'm not sure it goes anywhere, that having delegated and made a point about delegation, it has various advantages, including from equal pay and all sorts of other consequences. It then becomes more difficult for the minister to say, although we've delegated, we now direct you to do X, Y, and Z.
Yes.
And it looks as though the minister expressed his view and invited people to review.
Well, Lord, yes, the Minister for the Cabinet Office did express a view centrally as to what he thought ought to happen.
But he didn't purport to exert a power to direct. That would have been inconsistent with the general policy of delegation. That's the point I was making.
Exactly, my Lord, you're absolutely right.
You can tell from this that I was in Defra and Robertson.
Yes. So, just turning to, and that's referred to in one of the judgments because we thought to argue that as part of the contract point. So you can see that Kavanagh came on very quickly. Individual civil servants were seeking in a sense, a reversal of the removal for themselves. There is one other matter that I just want to refer to at this stage in terms of timings, is that in Smith, which is the Mr. Justice Friedman case, at around the time that check-off was being removed, so the last check-off deductions were made on the 1st of May 2015. A couple of weeks earlier, 15th of April 2015, there was a letter before claim written to HMRC on behalf of 2 claimants, civil servants, who are not claimants in the Smith case, threatening injunctive relief, and in a sense threatening to go down the Hickey line.
And how do we know that? Apart from
My Lord, it's in the
judgment?
supplementary bundle at 146. I'm going to take you to that in some detail, my Lord, a little bit later. I'm just highlighting it now. It was responded to, and it says if you don't reverse it, we're instructed to issue proceedings.
Yeah.
It was responded to in full by Government Legal Department,
So that's 2 individuals.
and nothing further was heard in respect of
Looks
that.
like, I hope I'm not too cynical, it's 2 individuals. However, their solicitors were Thompsons. So
Their solicitors were Thompsons.
we can
Oh.
assume that the PCSU was behind them.
Oh, my Lord, I don't doubt that, and any individual member of a trade union will know that where to go if they have
Right.
concerns. But a response was written by on behalf of the department, saying we're not removing, we're not going to go back on our decision, and yet nothing is heard until 5.5 years later, when the proceedings are issued. And my submission will be, and I'll go into some more detail on all of the cases, is that in those circumstances there must plainly have been an agreement to a variation by the individual claimants, and there must have been a waiver of any breach. If that is right, if there was a waiver of breach, then the PCS's claim fails.
But you're attacking a finding of fact.
I'm attacking a
There's
finding of fact.
no unequivocal abandonment or
Yes, I am challenging the finding of fact, and I'm absolutely. That is up front in our grounds of appeal. We're saying that the courts below got it wrong in a legal sense, and
there was no evidence upon which they could have reached the decision.
or their conclusion was perverse on the basis of the findings that they made, because they make some findings. There's some facts which clearly are findings. It's the inferences that they draw from those findings that we essentially are critiquing.
Well, let's wait till we get to that part of your submissions rather than trail them now.
And I'll just highlight that in one of the cases that we will be referring to, which is the Underhill case, which my Lord appeared in, made the decision.
I think he was the judge, actually. I don't
No,
think he was instructed.
Appeared in as the
I haven't
judge.
checked.
That on the facts of that case, the argument on appeal was a perversity appeal, and in a sense, we make the same argument here in respect of each of these 3 cases. So that's just the background, and I just wanted to set that out before we move on to the main submission. So I'm going to deal, as I said, with the 1999 Act first. The Contract Rights of Third Parties Act 1999, which are called the 1999 Act, reformed the rule of privity of contract, under which a person could only enforce a contract if he was a party to it. The 1999 Act, as you may well know, I'm summarising, there may well be lots of nuances. There are cumbrous trusts and so on which were applied and so forth, but in strict terms, that's the basis of the rule. The 1999 Act implemented the recommendations with some modification of the Law Commission, and there's a Law Commission report called number 242, Privity of Contracts for the Benefit of Third Parties. And we have extracts of that report in the authorities bundle. The 1999 Act only applies to contracts that were entered into from 6 months before the coming into force of the legislation. There has been some consideration of the 1999 Act at the appellate level, but as far as I'm aware, and I think my learned friend as well, there's been no consideration of it with respect to employment contracts, and certainly no consideration of the issues raised here of a contractual term which derives from a collective agreement between the employer and the trade unions.
There's obviously no doubt it does apply in principle to employment cases.
It does.
But
it does apply.
I have the impression, and you or Mr. Siegel can say this isn't right, that the Law Commission report was thinking very much in terms of a commercial context, and I don't know whether there's any consideration of how it might apply in an employment law context. The kinds of cases in which it could apply are very limited. This is obviously one.
Yes, my lord. I think my learned junior has read through the entire Law Commission report. I can't say that I did exactly the same, and I don't believe there's any reference in there to employment contracts. Well, or in any discussion, we know that it does apply to employment contracts because, and unfortunately, I don't think we've got the paragraph. Section 6, I think it is, deals with exceptions. Yeah, and it says it can't be used against an employee.
Ah, well, that is quite important because it suggests that Parliament, more realistically the Law Commission, is this one of those reports where there's a draft bill attached?
Yeah.
Yes.
Yeah.
Well, unless that came in later, I suspect that
No,
that shows the Law Commission did realise that it could cover employment cases. Yeah.
But there's no dispute that it can apply to employment
No,
cases
I know that.
as against the employer, but not the other way around. But the discussion within the report is as your Lord has pointed out, really deals with commercial contracts. The language that we are looking at for the purpose of this appeal really is that set out in section 1, which you find on page A11 of your authorities bundle. And only looking at sections 1.1 and 1.2. Subject to the provisions of this Act, a person who is not a party to a contract, a third party, may in his own right enforce the term of the contract if A, the contract expressly provides that he may, or B, subject to subsection 2, the term purports to confer a benefit on him. And we accept that the term here does purport to confer a benefit on the trade union.
Right, so the starting point is there doesn't have to be any contractual intention to confer a benefit on the union. The fact of the matter is the contractual term between the employee and the employer does confer a benefit, namely the facility
Yes.
for automatic deduction if authorised.
Yes. And then at subsection 2, subsection 1b, so where it's not expressly provided for, does not apply if on a proper construction of the contract, it appears that the parties did not intend the term to be enforceable by the third party. Now, I have a separate point which I'll come on to about does parties mean plural or singular. But for these purposes, I'll assume in my argument that it is the plural. Subsection 1b does not apply if in a proper construction of the contract, it appears that the parties did not intend the term to be enforceable by the third party. Now, what...
So just to spell it out, we've got a situation where the term purports to confer a benefit.
Yes.
So it says parties being A and B, A promises to B to pay C, so that purports to confer a benefit on C.
Yes. Then the question would come, is there anything on the construction of the contract to negative an intention of the parties that C should be able to enforce on that term?
because there's a certain amount of talk about a presumption, but in a sense the presumption is inherent in the factual. You wouldn't get. It's not in a sense a presumption. It's simply you wouldn't get to 1-2 unless the words, which is really what I think purports must mean, the words, the literal words, said that C should have a benefit.
Yes. But then one looks to see, on a proper construction of a contract, whether their right to enforce directly is negative, as in the intention of the parties is that they don't have a right to enforce.
Yes. The question must be whether they, notwithstanding the fact that there is a purported conferral of a benefit, whether the contract appears as an odd word, appears to demonstrate that they intended it should not be enforceable. Yes. That's what you're looking for. They've got to say to themselves, well, we know this is a benefit to this third party, the union,
yes.
But we, the employer and the employee, don't want the union to benefit. That's what you're looking for.
We intend that they not that they don't benefit.
Yeah.
We intend that they can't enforce it directly.
Okay.
Yes.
Because in this case, obviously, the individual employees, as happened in Hickey and it happened in Kavanagh, and it's
But that has to be a conclusion derived purely and simply from construction of the contract.
purely and simply from construction of the contract. So then the question is,
yes.
how do you construe the contract, and what is the and what sources are you entitled?
But it's important to make the distinction that emerged from the debate between you and my lord, that there is certainly a benefit being conferred.
Yes.
What you have got to construe is whether it was intended that that benefit can be enforced by the beneficiary rather than by the party to the contract, or in addition to the party to the contract.
So a classic example, and set out, it's one of the authorities in the bundle, it's the first discussion of it, is the Nishin case, which is a charter party case where, and I'm no expert about charter parties, but within the charter party there was a term providing for commission to be paid to a broker. And historically, the broker couldn't sue against the charter party or on the charter party for their commission. They had to be a co-plaintiff with the other party, and I think Lord Wilberforce referred to it as there was a cumbrous trust or something along those lines. The question then becomes, after the 1999 Act comes into force and you have a similar charter party, did the parties intend or not intend that the broker could sue directly? And Mr. Justice Coleman says, well, of course they did. They couldn't possibly have wanted everyone to go through that old cumbrous kind of way of a fiction, essentially, of suing through someone else.
And it's the term, not the contract.
It's the term and not the contract.
So it's the term which confers the benefit, i.e. the facility for authorised deduction of wages and payment to the union. And the question is whether on a proper construction of the party, it appears the parties didn't intend the union to be able to enforce that contractual term under which the benefit would arise.
Yes, and it's a question of construction rather than of the contract, rather than what's the meaning of the contract.
That's a rather.
Well, because one is not looking to see what's the meaning of the term.
Oh.
And why that's important.
Because by this stage you've already identified that it's to purport to give a benefit.
Yes, you've already.
Yes, but I mean, but in a sense that blurs the point which we just established earlier. There might well be a point about the meaning of the term, about what the benefit might be, or whether who the payment should be to. Not in this particular case. Those would all be questions about the construction of the term.
Well, they may go to the construction of the term.
And that would still be relevant if the employee chose to enforce. But now what you're construing the contract to see is if that term, however it is construed, is enforceable.
On the proper construction of the contract.
Yes, of course.
And the reason why I say that is because my submission is that the courts below erred in relying on a case called British Railway Board and Hooper.
Well, let's wait till we get there. Speaking
and
for myself, I
that's
can't see what
we're going
Hooper's
to
got to do with it.
The other thing that's relevant to that, because we are looking at the words of the statute, it's an odd phrase. It appears that, so we know the contract term confers the benefit, so we're not actually construing the term other than to see what the benefit is, because that may be relevant to assessing what the parties intend. And then you're construing the contract presumably as a whole to see not whether it does, but whether it appears that the parties didn't intend the term conferring the benefit to be enforceable by the third party. So if on a proper construction of the employment contract as a whole, does it appear that the parties wouldn't have wanted the union to be able to enforce the term under which they would otherwise get the benefit? That seems to be the question that 1-2 is asking.
That is the question that it's asking, and our answer to that is, in considering that question, in construing the contract, it is relevant to look at where did this term come from.
Yes, well, one factor you say may be the ultimate origin of the terms that were incorporated.
Yes.
Another factor might be the nature of the benefit in question.
And it might be the nature of the benefit in question, including for the fact that the individual employees can easily enforce the term themselves.
But they've got less interest in it because having a facility for voluntary deductions, that's why I'd be very careful about having you confirm what the term of the benefit was, because a voluntary facility for voluntary collection of trade union dues is of immense benefit to a trade union. It may be of individual benefit to the individual if he or she doesn't want to set up a direct debit, and it may also be that because it's effective for the union and they get more subs and so on, they can do more for the individual member as well.
But there is still the individuals do themselves have a benefit from it.
Yes.
There may be other contracts where the individual doesn't get a benefit from the third party benefit.
Yes, but it's piffling.
But two relevant factors, and there may be others, are the ultimate origin of the term in the contract and the nature of the benefit itself.
My lord, that is correct. And that one, we say you derive from the construction of the contract.
Hang on 1 second. The word purports, the more I think about this, is odd, because if, as I think must be the case, the structure of the statute separates out the giving of the benefit and the question of who can enforce that, there's no doubt that the employee can always enforce it.
Yes.
It doesn't really need to say purports to confer a benefit. Surely it should just say the term confers a benefit on the union.
My lord, I don't know why that particular
And
language.
it could be because if you then say it can't be enforced, it's not a benefit in the first place.
But it is a benefit in the first place because it's a benefit conferred by B, but for which the beneficiary is dependent on B taking steps to enforce it if it's not supplied. It is always a benefit. If the employer keeps the contract, there will be a benefit.
Yes.
And the term is intended to confer that benefit. That's why the word purports and it appears, because you could say on a proper construction of the contract, the parties did not intend. So I wonder why it appears that is put in. I know it's old-fashioned, but I just read the words in a statute,
Yes.
and I wonder what they mean.
My lord, I appreciate that. I do not know the answer to those particular to those particular.
And there's nothing in the Law Commission report?
Well, my lord, there may be, and I'm going to just take you to the Law
There
Commission.
is authority on what purports means, because it's referred to in Chitty, and I can't remember which case it is, but there is. I'm not sure. Give me a minute, I'll find it. It's in section.
The Chitty part.
It'll be somewhere about 300.
A299 is where it begins. A300, my lord, you are correct. It's term to 14.
Which page of the bundle?
A300, is that bit halfway down the page?
It's been held, if you page 300, yeah,
Has the
paragraph
effect,
2094, line 3. The requirement of the term as purport has been held to mean it must have the effect. And
Yes.
547 is, that's another disadvantage of having the thing, because when I looked at it in the book this morning, there 547 was happily sitting down below. But anyway, we can find that.
Or better still, you can find that.
I thought I would say that.
I mean, you didn't mean you, referring to my lord, I was referring to Mr. Feeney.
547 is, I think you'll find it at page 314, Prudential and Heirs, which is a High Court decision, reversed on different grounds.
Yeah.
So it's not binding on us, but that's what we've got.
Well, speaking for myself, I think I'd like to see that, even though it's not binding on us. So perhaps that can be done over lunch.
I think the Law Commission report might turn out to be very useful, actually, because I just looked at A202, and that said there were 6 tests considered at the consultation stage. And I look at the bottom, and one of those was that the third party may enforce a conduct which actually confers a benefit on him regardless of the purpose of the contract. So I'm beginning to think that they've looked at this and they've put the word purport in for a reason, but I haven't, I must confess, read the Law Commission report in total, or indeed the extracts of it, to be truthful, until now.
Who was the responsible commissioner? Was it Mr. Burrows?
Yes.
I will on this occasion say, as he then was.
Yeah.
well, you can do that, and I'll hold back. We will seek to get a copy of the Prudential case available for you over lunch. And if there's anything we can say about it. I did want to just take you to the Law Commission report for one reason, which is really to look at what they were saying in terms of the surrounding circumstances. Now, this is, in a sense, reinforcing the point that my Lord Justice Lewis has made, that one of the matters that you should be able to take into account on construction is the background to it. And you see a discussion at page 209 about the construction industry and subcontracts. And it's just an example, and then they refer in a footnote to House of Lords case.
Sorry, where are we? I'm on page 209. Where am I?
So, my Lord, it should be. It's basically all of.
Oh, we read the highlighted passages.
All of
Okay,
little
that's
three.
fine.
Yes, and
Yeah, okay, just give me one moment. I just want to look at how it fits in. I'll look at 717 first.
Yeah.
and then
That's standard stuff in construction contracts.
standard stuff in construction contracts. If one looks at the footnote, the reference to the Reardon-Smith line case, it's just so when one is construing the contract under section 1.2 in an employment context, by the same token, one should take into account what was the background to it, and I will say the background to it was that the union did not seek to have the right to enforce at the collective level the term which goes into the individual contract.
Say it again.
What, in the present case, the surrounding circumstances are that the check-off term derived from a collective agreement. The question is, we therefore need to think about the collective agreement. At the collective level, the ordinary understanding is that the terms of that agreement are not intended to be enforceable between the trade union and the employer.
Unless you make it a term of the contract.
Unless you make it a term of the contract, well, then it is a term of the contract which is certainly enforceable by the employee as against the employer. It doesn't mean, however, that it must also be enforceable by the trade union as against the employer through the individual contract.
The question is, what is the question different? If you'd never had the individual contract of employment, you wouldn't treat a collective agreement, because it's not an enforceable agreement, as giving rise to enforceable rights. But once you've gotten through that, you've got, for example, the top of page 209, the world has changed then. You've got a contract, it does confer a benefit, there's a rebuttable presumption the third party can get it, and any doubts are resolved in favour of the third party. You can't just say it's a collective agreement.
No, but one can.
And therefore,
but one can ask oneself, because at the collective level, the parties could agree that that term is enforceable.
yes,
The presumption could be reversed, and they've chosen not to make it.
But of equal force, although this is not my area, the parties could have said this is not enforceable by the PCS. Of course, it's difficult for your client because they're maintaining it's not contractual, so of course they're not going to do it, but they could have done it as a belt and braces. But given that it is contractual, in every other field of contract of which I'm aware, and I express no expertise at all in how employment contracts work, in every other field, if you've got something which is or could be giving rise to a third party right, you just put in this is not enforceable. Boom. Done.
Well, that is certainly something which is possible.
the problem is you can't just go from it wasn't enforceable at the collective level, therefore it would not have been intended to be enforceable at the individual level. There's a whole series of things. They have a collective agreement between two entities, a union and a government department, and the assumption is that that will not be enforceable. So if they agree that the government will provide a facility for authorised wage deductions, it's not going to alter the legal world. Once it's gone into an individual contract, the legal world has been altered. Because at least one person, the employee, can go to a court and say, they're not doing what they promised.
Yes.
And then the next question is, having gone through that particular set of legal changes, the next question is a different legal change. Given the Third Party Contracts Act, which said if it purports to confer a benefit, there's got to be a proper construction of the contract which shows they did not intend to do that. And you can't just go from the collective agreement to the answer at the third stage, because the legal universe has shifted, if you follow me, or may have shifted.
Well, my lord, my submission is that it is certainly relevant to consideration of whether it was enforceable, it's intended to be enforceable at the individual level, that at the collective level, the union did not intend for it to be enforceable.
But the question is whether the employee did. If you'd said to the employee, well, you've got this facility now, do you want the unions to have that benefit too? And that's a slightly different question from what...
But the employee, first of all, obviously one is looking at it objectively.
Yeah.
But the employee, looking at it objectively, would have in mind that at the collective level, the union had not sought to make it enforceable.
But you have to ask, rather than just trade these generalities to and fro, surely what you have to ask is, for what purpose is this thing which would work perfectly well at the collective level, because if, as long as the parties observed it, wouldn't need to make it a term of the employee's contract. You would simply provide the facilities of the contract to the employee in the usual way. So for what purpose has it been made as a term of the contract? And you would say, I think, it has been made a term of the contract through gritted teeth in order to confer an enforceable benefit on the employee, namely not to have to go through all the faff of having a direct debit. But not necessarily in order to confer an enforceable benefit on the trade union.
to
Which
confer
is-
a benefit on the trade union because they are the recipient of
Yes, but
the
I said
arrangement,
in enforceable.
but not to confer an enforceable benefit.
And one might add to that to give the trade union a right to claim damages if the or I suppose specific performance if a payment is in fact not made.
Because here we would say, why would one individual employee consider that if they were content to move from check-off to something else, even though it being removed as an entitlement, that the employer, so that the trade union would be able to sue for their loss of subscriptions?
Well, he might say to himself, I don't want to move to a direct debit, but I want my union to keep going. I've got no choice. But I would like them to carry on, but I'm too little and I'm too afraid to bring proceedings in the Great Big Court. But never mind, the union's got the benefit too, and I don't intend them not to be able to do it.
But if you're an individual, and there will obviously have been thousands of individuals here who decided not to continue with their membership of the trade union after check-off was removed. They chose not to continue making payment to the trade union. They have obviously decided, for whatever reason, that they don't need to be members of the trade union. Could they?
Putting it a bit high, I'm sure there's a very large inertia factor.
Yes.
Well, there might be an inertia
hatred of
factor.
paperwork, or even, no, I'm not being patronising, not really knowing how to set up a direct debit.
That obviously will be a matter to consider at the damages stage. But there must at least be some. If I put it as low as that, some individuals who decided I'm not going to continue my membership of the trade union because I don't need to do that anymore. Check-off may have been a simple thing, and it just happened. I'm not.
They could
doing it
always
anymore.
have, I mean, they weren't compelled to be a member of the union. It was that's why I keep going on about the term. It was a facility whereby they could authorise deductions, and that's gone. And many people don't like direct debits. Lots of suspicious people think, I don't trust that guarantee from the bank, because we've all had some people have had experiences where you try and get a direct debit undone.
But does every individual who has this contractual term intend that the union would be able to sue for damages in respect of them not continuing with membership of the trade union if check-off is removed?
Wrong question.
Wrong question is because they intend to enforce the contract, and the remedies are set out in subsection 5 of section 1, actually.
Which include
damages and specific
damages.
performance,
Which include
those injunctions, specific performance and other relief. It just follows. The question really is on a proper construction, on the proper construction of the contract, does it appear that the parties, the employer and the employee, did not intend the term providing for the facility for authorised deductions to be enforceable by the union?
Yes, and my answer to that is when the matter was considered at the collective level, the trade union chose not to set up an arrangement whereby it was enforceable by them as against the employer. That has some value and has some meaning, and the meaning of that must include we don't consider it necessary for us to have an enforceable right with respect to the check-off arrangements. When the matter then comes into the individual contract, that same intention must be part of the consideration when one is looking at the intentions of the parties.
Okay, but it can't be determinative. It can't be determinative because otherwise anything that came out of collective agreement would not be enforceable.
Well, it could be determinative if that is the most powerful factor on all, looking at all the evidence.
It's a relevant factor. Its weight will differ depending on the other factors in the case.
Yeah. Okay. Can I ask you a slightly different question?
Yes, my lord.
Would you accept that individual employees in this case would not be entitled to obtain an order for specific performance of the obligation?
No,
You might want to think about that.
I would have thought that they can seek
You
specific
think they
performance
can?
of the obligation because it's a contractual term which can be supervised by the courts. It doesn't engage issues of trust and confidence which the court wouldn't ordinarily supervise.
Isn't that what they got in Hickey?
Well, they got a declaration which is by the
Well,
the
that's-
same token
Yes.
a specific performance.
I mean, if it's
Because you
declared,
can't seek
the
specific
government's
performance
going
against
to
the
comply
government.
with the declaration.
You can't seek specific performance against the government. That's the as the government employer. But you seek a declaration, and that has the same effect.
Is that right? What is this? Some
I
constitutional?
think that is under the
The 1947 Act, is it?
Yeah.
Oh, okay.
That was certainly the view of the parties in the court in Hickey.
Didn't know that. But subject to that peculiarity, since Basic and Basic, you can get specific performance to make a payment.
Here,
Except this isn't basic and basic. Well, this is not. The reason why reliance is being placed on the Act
it's
is
because they
because of an
can't.
appreciation that the common law would not assist in including basic and basic.
Exactly. Well, that's the reason why they introduced the 1999 Act, among other things. The question here is whether or not there was an intention on the part of the parties that the trade union should be able to enforce that term.
Hang on one second, let me just write this down. Could someone give us the reference for that that point about the 1947 Act, 1947 Act?
Yes.
You can.
My lord, I was going to take you to the.
Hang on one second. See, what I've written down is, my Lord asked, could individuals set specific performance of the obligation to make the deductions and pay them to the union? Your reply, which I think Mr. Siegel goes along with, is no, because it's a government department. But otherwise, yes.
They can seek declaratory relief, which has the effect of specific performance.
No, all right, but I'm asking about specific performance.
My lord,
As against a government
as
department.
against the government department.
Yes, I know, but suppose it was a private. In principle, this would be exactly the same situation with a private
If it was
employer.
a private employer, absolutely
And
no.
they could get specific
Yeah,
performance.
there's no exemption. They could get specific performance because this is not a term that needs close supervision.
Probably a very good book somewhere that explains it.
Chichi.
Not a book on remedies in public law, by any chance.
Yes.
Yes.
Rush out and buy copies in the lunch hour.
But as against private parties, which I think is what my lord is.
Well, in that case, since my lord knows all about it, I let you after getting the 1947 Act. We'll ask him over lunch.
Well, I'll have to find that very good book. And I'll have to get the 47 Act, but I think that's where it comes from.
We will
It
look
comes
at the
from
book and we
anywhere.
will bring it to the court if we can. But my lord, our submission is that at the collective level there was no intention, and I haven't taken you through the authorities on that or the statute, but I think it's set out in the skeleton argument. I don't think I need to prove the point.
Sorry, to prove which
The
point?
point that the presumption is that a collective agreement is not legally enforceable.
Oh, yeah. We know that, yes.
And what is happening here, and this is why the intentions are negative, is that to hold otherwise would be to allow the trade union to get through the back door what it did not seek to get through the front door.
How do they do that? By on your basis, how does the union do it through the front door?
Through the front door, it could have.
Do they then come and get another collective agreement that this will be a term of the contract? Or?
Yes, they could have negotiated with the employer, the government, back in the 1960s, that particular term, because it was so important to them that it should be legally enforceable between them and the employer. They did not do so.
At the level of the collective agreement.
At the level of the collective agreement.
Yeah, it wouldn't have to be done back in the 1960s. You'll say at any
And
point,
they could have been done
in principle, they could have said in this year's pay round,
Yes.
or this year's negotiating round, we're going to ask for this.
This is so important to us that we require it to be a legally enforceable term vis-a-vis the government at that level. They chose not to do that, or they continue to choose not to do that, and that's the point that I'm seeking to make. That is also, I say, the view of the academic commentators who looked at this, and you have reference to that at A350. I think we pick it up at A349. This is from the textbook Labour Law by Collins, Ewing and McColgan.
So is that Professor Hugh Collins?
That is Professor Hugh Collins, pioneering professor.
Oh, sorry, it is, yes. I hadn't
And
got to the
Professor
page.
Ewing
Yes.
and Professor McColgan. And then at 350, they actually deal with this point that they raise a doubt, they raise a concern. And you see that A350.
Well, we can't see 350 because of the way the bundle's been.
But
Printed
it's
black
actually
on
the
black.
last page in the bundle.
Page 622 of the...
622 of the tome.
Yep.
And it's the middle. It's the first paragraph. They're dealing with the Chekhov. They've dealt with Kavanagh and Hickey.
Yeah, let me just... Yeah, well, that's very much in your favour, but doesn't necessarily mean it's right.
That doesn't mean it's right, but it means that those who had.
Has this been? I imagine you've looked at all the textbooks.
This is the only.
What about in Deakin and Morris? Not
I
covered.
think this is the only reference that I find to this particular point.
What's that? Since then, the Trade Union Act 2016 includes provision authorising the making of regulations to prohibit public sector employees from operating check office facilities without charging the unions in question. Gosh, have they made regulations like that? Yes, they have. Gosh, okay.
But not in Wales, my lord. We're pleased to see.
Yes.
And my lord, in this case, because I'm seeking to appeal, I say that the judges below erred in their approach to this because they did not take into account, as part of the surrounding circumstances, the intentions of the party at the collective level. Mr. Justice Choudhury.
So you don't have to say. We'll have to look at the reasoning. You don't have to say perverse. You can say it's. We can see from the reasoning they failed to take this matter into account, and therefore, you, the Court of Appeal, can make up your own minds.
Yes. On this, I don't. This is not a perversity challenge. This is they erred in law by ignoring the surrounding circumstances. They effectively said it's irrelevant, and they relied in doing so on the case of British Railways Board and Hooper.
Right. Is that where we're going next?
That is where we're going, and all I really need to take you to, my lord, is the judgment in Cox.
Yeah.
At paragraph 79. It's page 116, my lords.
Sorry. Case.
So this is
116. Give me a
within
moment.
Cox. Within Cox.
Oh, yeah. It's my fault. I was looking at Crane.
Paragraph 79.
Yeah. Yes. So you say that. So that. Okay, you're about to show us Hooper. Is that what Harvey says, by the way?
That is what Harvey says, and
Give us the page reference to the bundle for that.
I think do we have Harvey's?
We do.
Yeah. It's at the back.
But it's the reasons that 79 is just summarising the argument. It's the reasons that we need to look at.
Yes. My Lord, it's at page A257.
And you say 80.1 is wrong.
Yes.
Sorry, I'm just behind. So what, at A257, para 62, once incorporated into an individual contract of employment, a provision which owes its origin to a collective agreement falls to be construed strictly, yes.
My Lord, I'm not saying that that is wrong. What I'm saying is...
Well, no, I haven't finished reading it yet. Yes. Well, that 62 is obvious.
Yeah, my Lord, I'm not disagreeing with that. What I'm disagreeing with is it's the application of that at 80.1, as my Lord
Yes.
Justice Lewis said.
Can I just mention at this stage, I don't think it's, well, this may just be a judge always thinking his own judgments are the most interesting, but you might just care to look at, if you haven't already, a fairly recent decision of this court called Tyne and Weir Metropolitan, something like that, which is about rectification of a collective agreement. And there are various points in it, but one is that we said, or at least I said, because we didn't all agree on all points, that in considering whether a collective agreement could be rectified because it didn't represent the expressed intentions of the makers, although the contract was only rectifiable as a term, only the individual contracts of employment were rectifiable, yes. Couldn't rectify the collective agreement as such. Nevertheless, the relevant intentions would be those of the union negotiators. Now, it's not quite the same point.
No.
But, and I just want to...
Thank you very much. The way in which you've described it, my Lord, suggests that there may be...
Well, because we're not looking that in rectification, you're looking at the actual subjective intention.
Yes.
Truthfully, although we vary how truthfully we acknowledge this, when we talk about the intentions of the parties as a matter of construction, we're trying to establish the intention. It's an objective. It is an objective test.
Yes.
But anyway, but
we'll certainly have a look at that to see if it provides some assistance. But what is, I say, clearly an error is 80.1, where His Lordship, Justice Choudhury, says several difficulties with the argument. Firstly, it presumes that the intentions are relevant to construing the intentions of the parties, which are different from those at the collective level for the individual. This is not correct, as is made clear in Hooper. That is not what Hooper stands for.
Well, if you take out the last sentence, do you quarrel with 80.1?
I also quarrel with that because the intentions at a collective level may well be relevant.
Because the individual employees may have a similar intent, or if they're just giving effect to something that's been collectively agreed, you would say, why would they intend anything different as a result of incorporation? That's your argument in a nutshell.
Is there any real dispute about this? I mean, the fact that it derives from a collective agreement in the mists of time, all you're saying is it's part of the admissible factual matrix when you come to construe the contract.
It's part of the surrounding circumstances from where we construe the contract. Yep. And one relevant factor, I say it's a very important factor, is that, and I say it's determinative in this particular case, is that there was no intention for it to be enforced, and I've talked about the front door and the back door.
Yep.
Are there any other errors then in 80.2 to 80.6 and the other 5? He gives 5 reasons why he doesn't accept it. So the 80.1 is wrong.
Well, my Lord, I'm going to go through each of them if I can. So the second point...
You haven't actually taken us to Hooper, but I think we are all, subject to any attempt by Mr. Siegel to revive it, it's pretty clear just from the bit that's quoted in Harvey that it's on a different point.
It's on a different... My Lord, I mean, Hooper is in the bundle, and it really is about the employer thought at the collective level that they had agreed one thing, and then it was read.
And it also, I think, had a point about how they behaved subsequently. And Lord Justice Ralph Gibson says no, ordinary contractual principles apply. You don't look at the subjective intentions of sections as far as they're expressed.
Yes.
He didn't have to think about rectification, though he might have done.
Yep.
And you don't have to, you can't look at how the parties behave subsequently. Rule I've always thought was rather odd, but is undoubtedly orthodox.
So, my lord, going through the rest of his judgment, I mean, so I'm not going to go to Hoover. I don't think we need
Okay,
to.
well, you can come to it in reply if
The
What's wrong with 80.2?
so if one looks at the final sentence, what is said there is it is advantageous to the employees that PCS can directly enforce those arrangements, since the employees then have the security of knowing that their union subscriptions will continue to be paid uninterrupted. But they have that right themselves, which is what they exercised in Hickey. And as this is a trade, these are employees of, who are members of a trade union. They may well know that the trade union itself will back their enforcement of the term through legal proceedings. So they don't need.
No, but it's not a question of need. It's going back to the language of the Act. Did not intend, on proper construction, did not intend. So why should you assume that they wouldn't intend the unions to be able to enforce it?
Because
it may be beneficial to them. They may be able to do it themselves. But the fact that they don't need it doesn't mean that they therefore don't intend somebody else to be able to do it and help them out.
But the rationale here is that it's advantageous to them that the PCS can directly enforce it.
Isn't your better point that, again, he is treating your case as higher than it in fact was? Or he's tilting to, I don't know what metaphor to use, but if you look at the beginning, what he's attempting to rebut is an argument that any intention of PCS had at collective level must necessarily be consistent with the intention of different parties to be construed at the individual contract level. I don't think you need to put it that high, or do put it that high.
I don't think that.
You say it's relevant.
Yes.
And so what's wrong with 80.2, as I understand your analysis, is that proving that there might be a difference, he says, well, as soon as I see there might be a difference, then I don't look at the collective background at all.
Yeah. But throughout this, he's refused to look at the collective background.
Yeah. But it's the first two sentences I think really are wrong, not the last sentence, on your case, that is. I'm not saying it is wrong, all right. But in fact, it's what my lord said. It's about the first two sentences. Again,
it's
he's
a repeat
assuming too much.
It's a repeat of what he said at 80.1.
Yeah.
So, and then he gives us an example, and that's where I go on to say it's not necessarily advantageous to the employees, because the employees can clearly enforce it themselves, as was done in Hickey. Then the third point is an argument or some reasoning that the term of a collective agreement can continue to be enforced at the individual level, even where the collective agreement ceases to be in force. But my submission is that doesn't really add anything.
We haven't got Morris and Bailey in our authorities. I can't, and I didn't last night, I'm afraid, look it up. What was the facts of Morris and Bailey?
I'm not sure if we do. No, I don't think we do have in the bundle.
Well, I think we ought to. This is an important building brick of the.
But my lord, it's the principle that we're looking at. I think we would accept that a collective agreement can have disappeared. There may be no more union. There may be, or the collective agreement's coming to an end.
Yes,
the term has crossed the bridge.
Yeah, a very simple example would be that they negotiate for a particular year a pay increase of £1,000, and in the course of that year or thereafter, in any event, the union is derecognised, the collective agreements are Of course, they're never enforceable in the first place, but they are terminated. But the employees still have the benefit, because at the moment of the agreement came into force, it crossed the bridge into their contract. Yes.
So
okay.
I don't think the facts of Morris Bailey are relevant.
Let's just in case have Morris and Bailey, but I'm sure that isn't the only point. In which case you say yes, but so what?
But yes, but so what? They didn't have an interest at the collective level to have this as an enforceable term. Why do they therefore have an ongoing?
I had thought you were going to say something else was wrong with it, but maybe I'm wrong, because it matters not whether the union retains an interest because the collective agreement is gone. That's the wrong time and the wrong question. The question is, when the contract was made between the individual employee and the individual employer, did they intend that it shouldn't be enforceable? Yes. So that's the question. So I just wondered whether that was your criticism, but not necessarily by the sounds of it.
Are you jumping on that bandwagon, or?
Well, my lord, I'm happy to jump on that bandwagon. The fact is, my lord, it's a repeat of the same point that we've already made.
Just danger of repeating a point you've already made again. Is there anything else apart from the fact that it emerges from the collective agreement upon which you rely as showing an intention of the parties that it shouldn't be enforceable?
Other than the fact that they can themselves enforce it, and there's a reason for them to want to enforce it.
The fact that they can enforce it is neutral at best, isn't it?
No, but it's a term that they would have an interest in enforcing. As in the individual employee, the individual employees.
The individual employees.
So, my lord, in a charter party situation,
that's neutral, isn't it?
Well, no, because in a charter party situation where there's a commission being paid to a broker, the other contracting party may have no interest in enforcing it. It doesn't matter to them whether or not the broker gets paid or doesn't get paid. Here, they do have an interest in enforcing it, and there's no impediment to them enforcing it. So,
why don't they also have an interest in somebody else who's bigger and got more money also being able to enforce it, and a greater interest because they'll be enforcing it for lots of people? I mean, I know they can do it, and they might have said, well, if asked, well, I'm not too bothered about the union, I'll manage my own affairs and I will do it. But it's also possible, on a proper constructive contract, we'll have to decide that they might have said, oh yes, that's a good idea, I can enforce it, so too can the union. And then there wouldn't be any evidence arising from the fact that they could enforce it themselves to indicate an intention that it could not also be enforced by a third party. Because it's not either or you only have the third party.
That would just be a factor to go into the pot. And in the pot that we have before Mr. Justice Choudhury is no reference to the intentions at the collective level.
Yeah.
Okay, now we're going through para 80.
Yeah, so
81, 2 and 3, you say are all variations of the theme. Collective intentions are irrelevant to the individual intentions.
80.4 is not a matter that there's no reasoning there because the matter wasn't further developed, so it doesn't add to the reasoning. And then the fifth factor, which is a contractual point, my Lord Justice.
So you say the fifth factor, you mean 80.5?
80.5 is looking at the contract itself, because in the contract there were a whole, so looking at the codes and the guidance and all these things, there were a whole range of other organisations where check-off, effectively, the same principle applies, where there could be payment deducted at source to a third party. And some of those third parties, and it's discussed in some detail in the cases, there were charities and all kinds of
But parts of them were parts of the department.
Some of the parts of the department, but others were charities and insurance schemes and also and so forth. And the argument that was made below, which is dismissed here, is that when construing the contract, one has to construe it as a whole, look at the other parties who had similar treatment, and would it have been intended that any of those parties would have been entitled to sue directly?
That's not the section 1-2 question. It's whether the term, we went through that at the beginning,
but
the term
but one
that provides the facility for the union.
Yes, but one looks at that because, my lord, it says in construing the contract. So one
whether
has
on
to-
a proper construction of the
So
contract,
one looks at the whole contract.
the term, yes.
And one looks at the whole contract and one can see that the contract contains a number of different organisations and entities.
Well, I'm sorry, I missed all that. Which bit of the contract contains all these other?
So, my lord, further back in the...
Just show me.
So, my lord, look at, if one looks at paragraph 20 or 19 as an example, this is the prison officer's handbook. Under heading, so page 98. Voluntary deductions from pay.
Yes, I see. Okay, no, that's fine. So
Insurers, hospital funds, payroll donations, charity, lotteries, and so on.
Okay.
But it's not one out, all out, is it? You could easily have a situation where you, depending on the facts of the case, decided that no contrary intention had been shown in relation to organisation A, but for reasons which could include the nature of organisation B, you could conclude that the same term there's no intention to...
Well, my lord, that is a permissible outcome. The question is whether or not in construing the contract you take into account the fact that there's a whole range of other parties who are to be recipients of the same measure.
Could, if the contrary intention was not shown.
Yes. But when one looks at the intention, one can also ask oneself, well, they didn't intend for the whole swathe of organisations to have it enforced. Well, that can give rise to an inference that they didn't intend it here as well.
One out, all out.
One out, all out, or let's look at the weight of how this contract is written. But that is rejected in its entirety by Mr. Justice Choudhury.
Well, it rejects its entirety. He says what my lord put to you, that you would depend on the organisation. You make a choice.
Yes, but one also needs to look at the weight. The fact is that...
Okay, but he did... Okay, it depends what... He didn't attach any weight to it for that reason.
Yes.
But that doesn't mean that he ruled it out in life. He took that factor into account and found that it didn't have any particular weight.
And my submission...
That's not a misdirection, is it? If he makes a misdirection somewhere else, and we are doing the exercise ourselves... Yes. You could invite us to attach rather more weight to it than he did.
My lord, that is essentially what I'm asking you.
Yes, I see.
Because I've already made the submission that there's an error of law at the outset.
Yeah.
And if this court is looking afresh at the contract, that is a factor for you to take into account. That there are a whole range of organisations for whom a similar benefit appears on the face of it, purports to confer a benefit, would fall within the 1999 Act on the face of it, and it would be ludicrous to think that anyone intended, that the parties intended that those third parties could sue if the payroll deduction arrangement was withdrawn. And therefore, that must add some flavour to considering what about this particular term in respect of trade union. In Smith, Mr. Justice Friedman added a couple of further...
What about 80.6? You haven't looked at that either.
Sorry, 80.6.
There are two things. One is it's an error, and second, as I understand it, if you persuaded us that there's one or more errors, we'll go back and do it ourselves. So we'll have a look at the reasons of, as experienced in employment judges, Mr. Justice Choudhury.
Oh, well, I mean, so the answer to that is, my points are 80.1 to 3, which is the collective agreement, and then at 80.5.
Yeah, but then isn't it a strong factor against that, that the one that they haven't done is expressly excluded, as they could have done? The employer and the employee could have provided that. There's nothing in the wording to indicate that they didn't intend the benefit to be enforced by the third party.
The fact that they hadn't made an express...
You're looking to see whether they intended it not to be enforced.
Had
The
they-
best evidence of that would be if they'd said it.
Had they expressed that, then we wouldn't be here arguing the point at all. So one has to assume that they haven't expressly set it out.
1.2 is basically 1.2 is designed for the situation where the point hasn't been addressed. entirely true, actually. Never mind. Okay, now,
So, my lord, I just
you want us to look
I
at,
need you to
you
look
want
at-
us to look at Miss Justice
because-
Friedman's
because this
judgment
just
in
because
Smith.
that would be my answer. Those are my submissions on top, which are, I believe, repeated in Crane, but in Smith or HMRC, which you pick up at page 16 of the Smith bundle, some further points are made.
Which para are we
So,
looking
my
at?
lord, I'm looking at paragraph 112, which is page 49. It's really another way of saying the same thing as Mr. Justice Choudhury, where he's saying that, well, it's not the collective agreement that's being enforced.
And it's
It
one of
doesn't
three.
matter.
He says, Cox says it's of no relevance. Yeah. And he relies on all the things that Mr. Justice Choudhury said.
Yes, but what you were about to take us to some bits where you said where he makes additional points. Where are they?
So well, that's one way in which he phrases it differently, albeit it's the same point. And at 119, he's referring to the industrial relations backdrop, which is that the
Oh, I
employer.
see, yes. Where did you get that from? I didn't know that was some. Is that where's the encouragement he is referring to by government departments to tell people to join unions?
Yeah, that it in the bundles, and I think you have some of them in your supplementary bundle. There were the offer letters and statements of terms and conditions that were sent to the individual claimant.
Well, they're probably referred to in the judgment, aren't they?
Oh, I see. Sorry, you wanted it in the judgment. I beg.
Well, I don't suppose he would have said something like this.
No, I thought you wanted the primary documentation.
No, where does he make the finding that that was a government position?
Well, my lord, I'll-
just for my note.
We'll seek to find that for you. It may well be in there. So,
Well, I assume it is, but I agree if it isn't in there, then you better show us the material that Mr. Seager referred to. Okay, we can do it later.
but my lord, merely because there's an encouragement to join a trade union doesn't mean that there is an encouragement. That means that the check-off has to be enforceable at the hands of the.
No, but it might make it
union.
less likely that they intended it not to be enforceable. If they're told this is a jolly good thing, they'll think, oh yes, that is a good thing. And that might make it more likely that they would say, well, yes, of course we want it to be enforceable.
No,
It's a good thing.
But it's not in the context. This is not in the context of this is why we're having check-off. This is in the context of generally we consider that joining a trade union is a good thing because government encourages joining trade unions. But
That may be an approach before someone took a slightly more aggressive attitude to check off.
it's even consistent with check-off because, as we'll come on to show, the different government departments took very great steps to assist the trade union in moving people from check-off arrangements to the direct debit arrangements. And there's nothing in the documentation to suggest that there wasn't a continued encouragement. So that point is at most a neutral point, but is not something which supports all negatives and intention.
Okay, is that all we need to look at in Mr. Justice Friedman's judgment?
That's all we need from that judgment.
Okay. Right. Now,
Well, those are my submissions on that.
thank you.
So my second point on construction, which I can take much more quickly, is the reference to parties, plural or singular. Because and underlying the submission is that even if the individual employees intended, the government employer didn't intend. And the
How
que-
could that be a construction of the contract?
from looking at the construction of the contract, going back to the collective term.
How could it be? How could you find in this contract an intention that one party did intend and the other party didn't intend?
Because one can look, my lord, at the documents which precede the wording.
But the whole point about a contract is it represents the joint intention, and it's where you find the joint intention of the parties.
Well, my lord, my submission is that parties under the Interpretation Act can be singular as well as
of course it can sometimes, but surely my lord's point's a killer, isn't it? If you're talking about the construction of a contract, which is finding necessarily the intention of both parties, however artificial that sometimes is, where the Act refers to construing the contract, it can only be the intention of both parties.
Well, my lord, it's construing the contract to look at the intentions, which is not an ordinary thing that the courts are asked to do. The courts
Yes, it is.
ordinarily asked to look at...
When you construe a contract,
You look
you're
at-
looking at the intention of the contract by applying
Yes.
conventional...
For the purpose, my lord, of deciding what is the meaning of the contract.
But the
intention
meaning
of the
is what the
parties-
parties intended.
Exactly.
The meaning is not necessarily dependent on the intention of the
No, I
parties.
think, but surely, there's a distinction between the subjective intentions and the intentions construed by the normal process of construction, which we all agree is objective. Wait for a minute. What my law was pushing to you, seems to be plainly correctly, was that when Section 1.2 refers to the establishing the intention of the parties as a matter of construction, can only have been referring to the objective intention of both parties.
As revealed by the contract.
As revealed by the contract and admissible surrounding circumstances.
Because what 1.2 really means is, if on a proper construction of the contract, the term was not intended to be enforceable. Now, I know you would say that's what the New Zealand one says, and that's not what this one says, but that's what it's driving at, isn't it? That looking at the contract, it was not intended to be enforceable, and that's just a shorthand. The reference to parties not intending is a shorthand reference to processes of interpretation.
My lord, one construes the contract, one looks at the source documents, the roots and so forth, to see where the term came from and so forth. And in carrying out that exercise, if one discerns that one of the parties had a subjective intention that it would not be enforceable.
But that's not a process of construction.
Also, how could you do it? You'd have to have a term of the contract which says, despite the fact of our agreement, one of us doesn't agree that it should be enforceable. That's just nonsense, contractual nonsense.
Well, neither party may agree that it's enforceable. It might not say that on its face.
Well, that's what we're looking at.
Yeah.
To see whether you can derive from the intention, from the contract on its proper construction, the intention of the parties to be that it should not be enforceable. That's got to be the joint intention of the parties.
My lord, I'm not going to push this point any further.
I think that's wise.
Given the
But
the
before you
reception.
go push it any further, I've just had a thought. I mean,
My lordship,
You're
may
going to be
I jump
trodden in a
on
bit
that
more.
bandwagon.
because you all said earlier that we're into 1.2 precisely because the contract of employment between the individual employer and employee doesn't provide for enforceability and non-enforceability. If it did, we wouldn't be here. So we're not construing the actual words in the document to see what was intended, because by definition they haven't set it out. And then you're looking at the contract between A and B to see what the position might be in relation to C. And that might explain why it says it appears that, because you're not working out from the contract what the party's actual contractual objective intentions are. You're working out what appears to be the position, given what's in the actual document between A and B. And then you might want to say, I'm not saying it's right, I'm then wondering whether you want to say, and the last bit is it appears that either the parties didn't intend it.
Well,
But you'd still be stretching it a bit.
that is my
wouldn't it?
that is my
That's your
submission.
submission, really, is it?
I can read. I read the room, and I'm going to move on.
Yep, okay.
So, my primary submission in respect to the 1999 Act is that it doesn't apply here, and therefore the
Yeah.
claim brought by the union.
No, well, we've been over that very thoroughly in
So
numerous
I now wish to deal with the issue of waiver and variation.
Yeah.
Well, aren't you going to deal with section 2, or are you not going to deal with section 2?
I'm going to deal with that
Retention?
after I've dealt with variation and waiver.
Right, okay.
Because if I can't establish variation or waiver, then section 2 and section 3 don't assist. If the court finds that the individual employees varied the contract, then section 2 is in play. If the court finds that there was waiver of the breach, then section 3 is in play.
Okay.
But if I can't establish either of those propositions, then one doesn't need to get.
But hang on, am I being stupid here? If you find that they waived or varied contract, that is to say, by accepting that it no longer contained an enforceable right.
Yep.
Well, no longer contained a right to check off, then you don't need section 2 and section 3.
One does need section 2 and section 4.
Oh, do you?
If there's a waiver, then section 3, I learned a friend, they conceded, section 3 provides a complete defence to a claim for the...
But why wouldn't it anyway?
Because the way in which section 2, the way in which the statute is structured, section 2 provides a mechanism whereby a variation by the individual parties to the contract does not extinguish the rights of the third party unless certain factors apply.
Okay.
Because in a sense, this is seen as, if we go back to the broker in the charter party, if the parties to the charter party agreed that the broker is not going to get his or her commission.
Okay, no, I think I get the point, and I'm sure I will when I think about it more.
So, my lord, one has to look at the contract, the statute, to see that.
But anyway, on any view, the starting point is: has there been a waiver or a
Has there been a variation?
Yes. Okay. So off you go.
And that's where I'd like to go next. So, my lords, in all of the three cases subject to this appeal, the trial judges erred, we say, in deciding that there had been no variation or waiver. Our submissions that on the facts, the only proper conclusion that they could have reached was that it was clearly a variation and a waiver. And I will go in this skeleton argument, and I'll take you to that a little bit later. I show how the judges made some factual findings which I say were wrong, or they drew inferences that were wrong, but I also say overall the conclusion that they reached was perverse. So, my lords, the starting point then is obviously the facts of the case, and then I'll deal with the legal principles, and then I'll seek to apply the legal principles to the facts. And I'm sorry if I'm repeating things that I've already said, but I think it's necessary to try and get this across. There is a lot of commonality between the three cases, although there are particular differences which I will point out. In common is the fact that there was total silence on the matter of the removal of Chekhov between either the individual claimants and the relevant government department employer, or the PCS and the relevant government department employer, for over 5 years from the removal of Chekhov.
Hang on 1 second. Yep.
Silence from the PCS. They never wrote to or communicated to any of the government employers that the individual employees continued to protest or did protest.
They had lodged a grievance.
Well, I'll
come
to that on one of the cases.
Yeah.
They lodged a grievance, but they didn't proceed with the grievance in accordance with the way in which the grievance
let's-
procedure.
Leaving aside the spin, they lodged a grievance. You said the grievance had to be lodged in one way, and we have nothing. I haven't seen the evidence about the grievance procedure to know whether you're right or wrong. But a grievance was lodged.
But they didn't continue to press that after they received a response.
One answer to that may be that they did. They'd lodged it. They didn't need to do anything else. You didn't proceed to deal with it, and we just don't know what's right or wrong.
I'll come back and have a look at that. But in Crane, for instance, there was no grievance at all.
Right, that's a different point. Yeah.
Crane, there's no grievance. Of course, in Cox, there is a collective grievance that is lodged, but lodged before check-off is withdrawn. And the point that I will be making is that protest has to be after. There has to be protest after the breach has.
Well, that can't be right. That can't be right.
Well,
If someone says I'm about to make a breach, but I'll do it in three months' time, and perfectly sensibly the victim of the breach lodges a grievance in the interval, you say that simply doesn't count.
it doesn't count on its own. It doesn't count on its own when there's complete silence for 5 years. Yes, I do say that. Because what should happen and can happen is employees can say, I am continuing to work under protest.
Yeah.
I'm continuing to...
Well, as in all these cases, it's a great pity that parties didn't formally state their positions.
Yes.
But they didn't. We got to work out what we infer from that situation.
Yes. From an individual, in terms of the individuals, none of the individuals expressed a personal protest. None of them indicated that they were working under protest, and nor did the PCS on their behalf intimate that they were working under protest. The judgments rely heavily on the fact that PCS was running a case against the Department for Work and Pensions, the Kavanagh case, and the fact that the government departments were aware of Kavanagh. Those are the findings. I can't seek to disturb those facts that there was a case called Kavanagh that PCS was running, or that government departments were aware that Kavanagh was being run. However, there was no evidence and no findings made by the judges that the government departments were aware that Kavanagh was being treated, being run as a test case.
I'm not sure that the words test case help.
Or
That's a label. There aren't test cases. In English and Welsh law, you bring a case, there's an adjudication. It binds the parties.
Yes.
It may be that other judges, at first instance, will follow them, and it may be, if it goes to the Court of Appeal, they're bound. But there's no magic to the word test case. The question is, how likely is it that if they won Kavanagh, that they would win the other cases too if they brought them?
And that they would seek to bring them.
Yeah.
There was the government departments were not put on notice. They were not told anything by PCS that they were treating the findings in Kavanagh as of value, let's say at a minimum, in terms of any case they might bring against.
Because they could put test case all over the pleadings in Kavanagh, wouldn't make a blind bit of difference to the other departments because they're not the defendant in Kavanagh.
But they didn't ever say that we will be relying on the findings in Kavanagh when we come after you. They were just completely silent in terms of their communications with the employers. And not only were they silent from the beginning when the proceedings in Kavanagh were issued, but even after judgment in Kavanagh. And that's of particular importance when one is dealing with the individual employees, because as at May 2016, there was a finding of the High Court that even where a term wasn't highlighted as a contractual term, that was a contractual entitlement of the employees in that particular department. But nothing was then said to any of these government departments, we are going to rely on the same thing with respect to you.
Was there an application to appeal Kavanagh?
As far as I'm aware, there was no application to appeal Kavanagh.
I mean, one view of this might be...
2016. Yeah, so 2016.
One
So
view
what happened in 2015?
No, so I said 2015, the judgment, it was 2016.
It's May 2016, I've got
yes,
that. Yeah.
13th
Okay,
of May
sorry, my lord was about to ask a question.
Well, I was just going to say, one view, might be a bit of a tendentious view, is that there was a reasonable expectation that faced with the judgment on Kavanagh, other government departments would fall into line.
Well,
I mean, okay, you've got an individual who was engaged on such and such a date, and you've got another individual who's engaged on another such a date, and Thompson's may or may not have written in particular cases. But once Kavanagh's decided, particularly if it's not appealed, doesn't that indicate as between these two parties who are looking for unequivocal statements. That there may be a reasonable time for the government to knuckle under.
Well, my lord, one would certainly expect, if one is getting into reasonable expectations, that the PCS might have mentioned that to the government department. To say, by the way, look, we've won in Cabinet with respect to these individual employees. Put to one side our claim for damages. We've got a finding in May 2016 that these individuals working under these arrangements have an entitlement to check off. If they were reasonably expecting that the other government departments would fall in line and reintroduce check off, one would firstly expect them to have said something. And from the individual employee's perspective, because ultimately here we're looking at waiver and variation by the individual employees, we're not looking at what the PCS did or didn't do, because that isn't that's not part of this case. The individual employees would have been aware, or should reasonably be taken to be aware, that on similar facts to theirs, I'm not saying precisely the same, a government department had said check-off needs to be, check-off removal is unlawful, those employees are entitled to have check-off. Those employees didn't say to their employer, I would like check-off back, please. And they didn't say anything for a further 3.5, even 4 years to say...
Going back to first principles, we've got a lot of the facts that you say are so outrageous it must lead to a particular result. What's the actual test? What is the legal test I have to apply to see whether these facts satisfy that test?
So for variation, there has to be an agreement.
And there's no express agreement here, so
it has to be an implied agreement based on...
So for variation, has to be an implied variation.
On
silence.
conduct.
And my lord, I'm going to take you through the cases.
Okay.
To deal with.
Okay,
that.
well,
But I'm at this stage.
we'll wait. Okay, possibly the wrong way around, but never mind. How much more are we doing on the facts?
My lord,
These are your key
only,
points.
Only these are my common facts, my key points. I'm just not very long.
Okay.
And then I will get to the law. Because my point here is we're looking at the individual employees. They have a contractual entitlement to check off, which is taken away in whatever date, early 2015, let's say. They carry on working. They don't make a protest. These claimants actually move over to direct debit. If they wanted the term to be, the taking away to be reversed, if they wanted check-off to be reintroduced, one would expect for them to say so. If it mattered to them sufficiently, they would have said so. They don't say so at any point in time. They could, and I say reasonably should, have asserted their rights quickly, as was done in Hickey, as was done in Kavanagh. Because if you care about a particular term, you want to vindicate your rights quickly. If you care about check-off, you don't wait for 6 years to say, oh, by the way, I'd like to have it back, please.
Yeah, okay, we got the point.
So that's my point. And as we know, this is not a case where the individual employees are seeking damages. It's not as if they're, and that's not part of the prayer, as my Lord or Justice Stuart-Smith has already seen, because they have suffered no individual loss. That is, and we'll look at the case of Appellant shortly, that is a material difference with the Appellant case, where there is a period of 2 years before the claim is brought, but there is a claim for damages, for arrears of pay. So, yes, strictly speaking under the Limitation Act, one can bring a claim within 6 years from the breach. That of course, is what the statute says. But when considering variation and waiver, one has to look at what happened in the meantime.
Yeah, got the point.
And I'm going to say, they carry on working, they move to direct debit, which achieves exactly the same result for them as check-off, because their dues continue to be paid.
We have got the point.
Do all the individual claimants that we're concerned with go to direct debit?
They will move to direct
Every
debit.
single one.
They will move to direct debit.
Need to be careful with that, though. All they need to do then is find one that didn't.
I don't think any of the claimants...
No, I know.
Yes.
They'd find a new one. We didn't move direct.
Well, now they'd be out of time, because
Yeah.
they brought the claim on on the cusp of 6 years, and
That's
for,
true, so they
for
can't
whatever
get
reason they
another one
couldn't
now, yes.
locate someone who we'd say
Yeah.
because they didn't want to continue to be a member of the union.
We don't need to worry
Otherwise they
too
would
much
judge-
about
they
putting
would
too
judge
much
it.
weight on that then, yeah. If we do put too much weight on it, it's not going to create problems in other cases.
So I will move on to the law, and then I'll come back and look at the detailed facts later.
Yeah.
So many of the leading cases in this field were discussed by the Court of Appeal in the Appellant case. And of course, my Lord Justice Underhill, Vice President, gave judgment in that case. There is also, however, a judgment of Sir Patrick Elias, which I will take you to because it contains some what I regard as important points of principle which you should take into account. In Appellant,
I'm pretty sure, obviously I know about it.
it's 173.
I think my lords have both read it, so again, you can be.
I'll be very brief. It's
No,
simply,
it's an important case, but you needn't touch over the facts in great detail.
the background is that employees did not receive a pay increase for a period of 2 years, and then they didn't receive a pay increase after that. But the claim was with respect to the 2 years where they didn't receive a pay increase. In advance of the decision of the employer not to make the payment on the annual basis, there had been protest, and in fact there had even been a ballot for industrial action, but that didn't achieve the necessary numbers. But there continued to be some protest after the decision was taken that payment would not arise, or after the date upon which payment should otherwise have arisen. On those facts, even though the claim was brought 2 years after the non-payment, it was held that they were entitled to payment, and there hadn't been a variation of the contracts. On appeal, the argument was essentially one of perversity. And during the course of the decisions, there is a consideration of all the relevant cases in this field, or the leading cases in this field. And in his lordship's judgment, he explains how the cases, and we're dealing essentially with, there's a House of Lords case called Rigby and Ferodo, there's an Employment Appeal Tribunal case called Jones, there's another Employment Appeal Tribunal case called Selectron, which are sort of the main case, and another, I think, a Court of Appeal case called Choudhury. But what Lord Justice Underhill said, how he analysed the cases, he drew a distinction between a variation of terms, so really we're talking about a unilateral variation of terms by an employer, which have an immediate effect, such as a pay cut, and those which would only be felt sometime later, such as a change to a term relating to restrictive covenants, which would only be of relevance when someone is seeking to leave their employment, or redundancy entitlement. And in the case of those latter cases, the courts had been slow to endorse the suggestion that merely continuing to work constituted acceptance of the varied term. The position was different, however, where the change in term had an immediate impact. And our submission is that the present case falls into that category.
Where do you get different from in the judgment? You
But
can
Lord,
take
I'm going to,
paragraph.
I'm just making some general principles, and then I'll show you.
And did Lord Justice Underhill, in his great experience and wisdom, anticipate this sort of case where it takes immediate effect? It's not actually taking money away or putting in an immediate adverse effect. It's an immediate effect in the sense of it withdraws a beneficial facility, which might be seen to be sort of midway between the two.
Well, I don't believe that Lord Justice Underhill did anticipate a case like this. But,
Well,
my
if
Lord,
I did, I didn't say anything about it.
yes, we did, exactly that. But my Lord Justice Lewis, my position is that this is an immediate practical effect, because on day one or day zero, the employees didn't have to do anything.
That's why I added a word, you see. I didn't say immediate practical effect. I said immediate adverse practical effect, like having a pay cut. Now, I know that at one high level, adverse withdrawal of the facility, but it's clear that I'm struggling towards finding a form of words, which we won't quibble about the form of words, but it captures a situation where somebody is has less money in their pocket at the end of the week, might be different from somebody who'd like to have something done, but it isn't done.
Well, look, I'm certainly not saying that this is equivalent to a pay cut. Yep. But it is something where there's an immediate effect.
There's an immediate alteration in the state of affairs. The benefit is withdrawn immediately.
The benefit is withdrawn immediately, and it is seen to be an adverse effect to these individuals.
And there will be an immediate adverse effect
Because
they either have not to give up their union membership, but I think we should assume that for these purposes, that they want to continue to be members. So they have to go away and go to the trouble, possibly even some expense, depends on your bank, in setting up a direct debit.
It's only time and effort.
Yep.
Yep.
For those who want to continue.
For those who want to continue. Now, those who don't want to continue, my submission, and it may be that we don't need to make that submission here, but it's a submission for remedy, is that they vary the contract and waive the breach immediately, because they're not interested in this term.
Well, their conduct is consistent with saying, well, I could have just gone down to the office and signed the form and said, no, don't do it anymore. I don't need to anymore. That's not a variation.
Well, it's a variation in that it's taken away. Their authorisation is taken away. They don't replicate it by doing the direct debit.
Yeah.
Yeah. Okay.
They don't achieve the same outcome, which is what the check-off is to achieve an outcome, which is the payment of dues.
There's a change in the legal universe. Their authority or their authorization no longer produces a lawful deduction of wages, but they don't replace it with a different event.
But their authority has been revoked. Their authority has been revoked.
So that is a change.
That is a change.
It is a change.
And
even if they decide, oh, that was good, I wanted to resign next week.
but when they don't seek an alternative, we say that must be treated as a waiver and a variation. But they're not the cases in front of us today. But they may be relevant for a remedy here.
I see the time.
Yes, my lord.
Let's break off there. Remind me what the estimate was originally 1.5 days.
Before we had the
So it's-
Smith case added, and I believe, although I'm not sure I've seen anything from the court to confirm this, but we certainly asked for 2 days.
Yes, well,
And
in truth, Smith adds almost nothing to the time. I think we are still expecting the parties to finish in 1.5 days. We'll see how we go. I appreciate we must play our part in that. I'm not asking you too many questions.
my lord, I'll do my very best to conclude
but-
this afternoon.
I think you should certainly conclude this afternoon. I was hoping you would conclude before the end of the afternoon, but we'll see.
My lord.
At the risk of making myself seem still more vain, on an issue you haven't yet come to, which is the question of when a contract is entered into, when someone is promoted, fundamental change and so forth. I did have to look at that at first instance in a case called Pat Systems and Neely, Neilly. In fact, I said very little of interest about it, but it is simply a useful way in to what were then quite a lot of cases about it. And the only case we've been given is Farnworth, isn't it?
Yes.
There's quite a lot. I'm not asking to be shown lots of cases, but I want to be confident that you have seen them all. And they are referred to there or in another case, which I cross-refer to, a decision of Mrs. Justice Slade. And I think there's also a reference to Friedland on the contract of employment. You might just want to look at those. I'm not saying I'll be cross with you if you don't follow them up, but
We'll do what we can.
say Farnworth seems rather a thin authority on an area where there is quite a lot of law.
I think, my lords, it's Mulchrome that's the authority that's on point. plant.
Oh, I see. I'm sorry.
Well, no, so
Fine.
Malcolm is the case under the 1999 Act.
Yeah.
So you're referring to the general question of when do you enter
Yes,
into the
exactly.
contract?
The employment contract.
Yeah.
Yes, which comes up in a lot of compact systems, and Neely was a restrictive covenant.
Yeah. So, but my lord, just Neely, it's Neely.
No, Neilly.
Neily.
But no, because this question comes up
Yes.
in a variety of different contexts. One, which was Pat Systems, was a restrictive covenant, but it can also come up in cases of various statutory rights important when a contract is entered into. Okay.
Thank you.
Well, I think I'll be strict and say 2 o'clock. Okay.
All right.